The highest court in America just changed the rules of an election while people were already standing in line casting their votes, not before the election started, not months in advance, with time for courts and voters to adjust during active early voting. In the middle of it, the 6 conservative justices of the United States Supreme Court waived their own 32-day implementation rule, a rule that exists specifically to prevent last-minute chaos in elections, and ordered new congressional maps rushed into effect immediately. And this same court had broken that exact rule only twice in the previous 25 years. Both times, the beneficiary was the Republican Party, and that is just Louisiana. In Alabama, the same court cleared the way for discriminatory maps a federal court had already declared racially illegal, to be restored just 1 week before a primary election. 3 years earlier, the same court had blocked fair maps in the same state by saying that months away from an election was too close to make changes. Now, with 7 days left, they had no such concern. In Tennessee, the city where Dr. Martin Luther King Jr. was assassinated was carved into 3 separate congressional pieces specifically designed to ensure that the Black community that built one of America's most powerful civil rights legacies could never again elect a representative who actually reflects their interests. And when Justice Ketanji Brown Jackson, the first Black woman ever to serve on the Supreme Court, wrote a dissent documenting this pattern in plain language, Justice Samuel Alito did not respond with a legal argument. He wrote a separate opinion specifically to attack her by name, calling her dissent baseless and insulting, demanding she show more restraint. She did not back down. And by the end of this video, you are going to understand exactly why her refusal to stay silent may be the most important act of judicial courage in a generation, and why what is happening across Alabama, Louisiana, and Tennessee right now is not 3 separate stories. It is one coordinated pattern, and it is happening in plain sight. Let's start with Alabama, because the Alabama timeline alone makes what the Supreme Court just did almost impossible to defend with a straight face, and the court knows it, which is exactly why they did it anyway. 3 years ago, the Supreme Court decided a case called Milligan. That ruling forced Alabama's legislature to scrap its old congressional maps a federal court had already found to be racially discriminatory, and replace them with new ones, drawn by a 3-judge panel in Birmingham. Those new maps created a second majority Black opportunity district in a state where Black residents make up roughly 27% of the population. Alabama fought those maps at every step, and now the same Supreme Court has cleared the state to go straight back to the discriminatory originals. Here is the timeline that exposes everything. 3 years ago, when Alabama wanted to delay implementing the new fair maps, this same court hid behind the Purcell Principle, a legal doctrine saying courts should not change election rules too close to an election. The court used that principle to protect the discriminatory maps when changing them would have helped Black voters. They said months away from an election was too close to make changes. Now, with 1 week until the Alabama primary, the same court is making a major change to the same maps going in the exact opposite direction. Same state, same maps, same principle, completely opposite application. Former U.S. Attorney Joyce Vance said it plainly on air. 3 years ago, this court hid behind the Purcell Principle with months to go. Now, with just 1 week left before the primary, they suddenly rip up the rules entirely. The principle did not change, the beneficiary did, and that is the whole story. The Purcell Principle exists for a genuinely good reason, and understanding that reason is what makes its selective application so devastating to the court's credibility. Last-minute changes to election rules, even well-intentioned ones, create real chaos. Voters who plan to cast ballots in one district suddenly find themselves in another. Election officials scramble, ballots get challenged, results get contested in court for months. The Purcell Principle exists to protect the integrity of the democratic process from exactly that kind of disruption, and regardless of which party benefits or loses from keeping the existing rules in place. And that is the theory. Here's the documented practice. 3 years ago in Alabama, when implementing fair maps would have helped black voters access genuine political representation, the court invoked Purcell with months remaining before the election. They said the timeline was too tight, the disruption would be too great. Alabama went through an entire additional election cycle using maps a federal court had already declared racially discriminatory because the Supreme Court decided that procedural stability mattered more than correcting a documented legal violation. Now, 1 week before Alabama's primary, the same court makes a major last-minute change to the same maps. The Purcell Principle has simply disappeared from the majority's legal analysis. No explanation, no distinguishing of the cases, no acknowledgement of the obvious contradictions sitting in their own recent precedent. As Joyce Vance put it with precision, you just saw it with your own eyes. The court applied one standard when the outcome helped black voters and a completely different standard when the outcome helped Republican mapmakers. The principle is not dead. It is just conveniently unavailable whenever Republicans need it to be. The Supreme Court has a standard procedural rule that its decisions do not take effect for 32 days after they are issued. This rule is not complicated or controversial. It exists specifically to give lower courts and election officials and affected communities time to understand and prepare for a ruling's implications before it reshapes the ground beneath an active election. It has been standard practice for decades and exists precisely because the court understands that sudden, last-minute legal interventions in democratic processes cause serious, documented harm to voters. In the Louisiana redistricting case, the 6 conservative justices did not just issue a ruling, they waived the 32-day waiting period entirely and ordered the decision implemented immediately during active early voting, while Louisiana citizens were literally standing in line casting ballots in an election. This ruling was specifically designed to affect Louisiana Republicans needed the new maps in place immediately so they could begin redrawing congressional districts to dilute black voting power before the election concluded. The court obliged without hesitation and without any meaningful explanation of why this particular situation justified abandoning a rule they had maintained consistently for decades. Justice Ketanji Brown Jackson documented in her dissent the single most damning data point in this entire story. In 25 years of operation under this rule, the court had broken it exactly twice. Both times it was broken during contested elections. Both times the immediate implementation of the ruling benefited Republican electoral interests. A court applying neutral principles across a 25-year period does not produce a record where every single exception to its own procedural rules runs in the same partisan direction. That pattern does not emerge from neutrality, it emerges from intention. Justice Ketanji Brown Jackson did not write a polite disagreement in the Louisiana case. She wrote a documented indictment of what she believed was happening inside the institution she serves. She called the majority's action an unbridled assertion of power. She invoked the Purcell Principle they had abandoned without explanation. She laid out the selective application of procedural rules in plain language that any citizen could understand. She said what she saw, and she put it on the public record permanently. Justice Samuel Alito's response was extraordinary and extraordinarily revealing. He did not defend the majority's legal reasoning on its merits. He did not engage with the substance of her documented critique. He wrote a separate concurring opinion specifically to attack Justice Jackson by name. He said her dissent contained charges that cannot go unanswered. He called her arguments baseless and insulting. He accused her of lacking restraint. A senior justice on the highest court in America wrote a personal attack on the first black woman ever to serve on that court because she publicly documented what she believed was a pattern of selective rule application benefiting one political party. Jackson did not back down for a single sentence. She responded directly, noting the profound irony of being lectured about restraint by a justice who chose to write a separate opinion for the sole purpose of attacking her personally rather than addressing the legal argument she had actually made. As the original broadcast observed, when you cannot answer the argument, you attack the person making it. That is not judicial restraint. That is exactly what an institution under pressure looks like when its procedural defenses have already collapsed and all that remains is raw authority. Tennessee's Republican-controlled legislature did not accidentally produce congressional maps that eliminated the state's only remaining Democratic district. They produced those maps deliberately, methodically, and with full knowledge of exactly what they were doing. The method they chose was to take Memphis, a majority black city with one of the most concentrated Democratic voting populations in the entire state, and slice it into 3 separate congressional districts simultaneously. Each of those 3 new districts then stretches outward from urban Memphis into surrounding rural and suburban territory. One connects Memphis directly to Williamson County, one of the wealthiest and most politically conservative counties in Tennessee, the home county of U.S. Senator Marsha Blackburn and the state's Republican governor. The mathematical effect was immediate and clearly intended. Memphis's concentrated black Democratic voting population, which was previously large enough to elect a representative who actually reflected its interests, is now dispersed across 3 separate districts. In every one of those 3 districts, Memphis voters are outnumbered by the surrounding Republican-leaning communities they have been administratively attached to. Holly McCall of the Tennessee Lookout explained the human reality beneath the legal and political mechanics. The original Memphis district was not drawn arbitrarily. It was drawn because the people of that city share genuine common interests, economic, historical, and civic concerns that belong specifically to that community. Those common interests have now been deliberately separated across 3 districts, specifically engineered to ensure those interests can never again produce a congressional representative who reflects them. That is not a neutral redistricting exercise producing an inconvenient outcome for one party. That is the surgical administrative removal of political representation from a specific community, and it was done in plain sight with full documentation of the intent. Hold 2 things in your mind simultaneously, because the distance between them tells you everything about what is actually happening in Tennessee right now. The first is April 4th, 1968, the Lorraine Motel in Memphis, Tennessee. The moment the most consequential voice in the American civil rights movement was silenced by an assassin's bullet while standing on a balcony. Memphis carries that history in every street, every institution, and every community that grew from the movement Dr. King led and died for. One of his own attorneys, a man who fought the legal battles that defined the civil rights era, traveled to Nashville specifically to testify before the state legislature against these maps. That is how seriously the people closest to that history understand what is being done. The second thing is what is happening to that same city right now. Its congressional district is being deliberately sliced into 3 pieces by the legislature of the same state where Dr. King was killed. The community that built one of America's most powerful civil rights legacies is being administratively dismantled by political institutions that opposed that movement from its beginning and are now finishing the job through map-making rather than violence. Joy Spance said something on air that deserves to be heard clearly and completely. Seeing this done particularly in Memphis, where Dr. King was assassinated, where so many of the defining events of the civil rights movement happened, almost feels as though the legislature is imposing a punishment on one of the most well-developed civil rights communities in the country. Not a political calculation, a punishment delivered through congressional maps, protected by the Supreme Court, and dressed in the neutral language of redistricting reform. Numbers do not lie. And the number Justice Jackson put into her dissent is the single most statistically damning data point in this entire story, because it cannot be explained away by coincidence, oversight, or the neutral application of legal principles. The Supreme Court's 32-day implementation rule has governed how the court's decisions take effect for decades. It is not an obscure technicality buried in procedural manuals that nobody reads. It is a foundational protection specifically designed to prevent the court's rulings from destabilizing active democratic processes through sudden, last-minute legal interventions. Every justice on that court knows it exists. Every justice knows why it exists, and every justice knows exactly what it means to waive it. In 25 years of operation under this rule, the court waived it exactly twice, not 10 times, not 5 times, twice. Justice Jackson documented this in her dissent with the precision of someone who understood exactly how important the number was. Both times the rule was waived, the decision was implemented during a contested election. Both times the immediate implementation of that decision produced outcomes that directly benefited Republican electoral interests, 0 exceptions running in the opposite direction across a quarter century of jurisprudence. The mathematical probability that this pattern emerged from neutral principled decision-making is essentially 0. A court genuinely applying its own rules consistently across 25 years does not produce a record where every single exception to those rules, without a single outlier in either direction, runs in the same partisan direction. That is not what neutrality looks like. That is what a captured institution documenting its own capture looks like. And Justice Jackson made sure that documentation would survive on the permanent public record. One of the most revealing aspects of the Tennessee redistricting story is not what the Republican legislators did to Memphis. It is what they said while they were doing it. Because the gap between those two things is where the real story lives when challenged about the racial impact of splitting Memphis across 3 congressional districts, when confronted directly with maps that take concentrated black urban neighborhoods and administratively attach them to wealthy, white, suburban counties. Tennessee's Republican legislators claimed with apparent sincerity that race had nothing to do with their map-making decisions. They said they had no knowledge of the racial composition of the communities they were redrawing. In a state with documented racial residential segregation, in a city whose entire geographic and political identity has been shaped by a century of deliberate racial policy, in a redistricting process that every voting rights attorney, every civil rights organization, and every affected community immediately identified as racially targeted the moment the maps were published, Holly McCall put the denial in its proper historical context without hesitation. To hear Tennessee legislators claim ignorance of Memphis's racial makeup while drawing maps that surgically separate black neighborhoods from each other and attach them to Republican white suburbs, I think you have to say that we still have not gotten out of the Confederacy. The denial is not a defense. It is evidence. A legislature genuinely unconcerned with the racial impact of its maps does not need to loudly and repeatedly deny that race was a factor. The urgency of the denial in the face of maps whose racial targeting is immediately visible to everyone who looks at them is precisely what happens when you know exactly what you did and you need a legal argument that puts distance between you and the intent. Context does not exist in isolation. And the context surrounding Tennessee's current redistricting effort makes the stated neutrality of its Republican legislature impossible to accept with a straight face. 3 years ago, in the aftermath of a school shooting in Nashville that killed 6 people, including 3 children, 2 young black state representatives took the House floor to stand with students demanding action on gun safety. Representatives Justin Jones and Justin Pearson were expelled from the Tennessee legislature by their Republican colleagues, removed from office, silenced publicly, punished institutionally for speaking up about children being shot in a Nashville school. A white female representative who participated in the same protest on the same floor was not expelled. The same legislature, the same protest, the same day 2 black lawmakers removed 1 white lawmaker untouched. The Tennessee legislature did not even attempt to apply its own stated reasoning consistently across the three people it was evaluating simultaneously. Now that same legislature is redrawing the congressional districts that determine how much political power Black communities in Tennessee can exercise at the federal level. The people who expelled Black colleagues for the act of public protest are now carving up the geographic districts where those communities live, organize, and vote. As Holly McCall observed, directly knowing how some white Tennessee lawmakers talk to Black lawmakers. Race is definitely a factor. This is the institutional pattern that makes individual decisions legible. A single redistricting fight viewed alone can be framed as neutral political calculation. The same fight viewed alongside the expulsion of Black representatives for public protest, the denial of racial intent in openly racial map-making, and the deliberate targeting of Memphis. That pattern is no longer ambiguous. It is a consistent and documented institutional posture toward Black political participation. Individual decisions can be argued, patterns cannot, and the pattern documented across Alabama, Louisiana, and Tennessee in this single election cycle is the most important thing to understand about everything we have discussed. Alabama, discriminatory maps declared racially illegal by a federal court restored 1 week before a primary, giving Republicans an additional congressional seat. The Purcell Principle invoked 3 years ago to protect those same discriminatory maps suddenly unavailable when removing them would have helped Black voters. Louisiana, the 32-day implementation rule abandoned during active early voting, so Republican mapmakers could begin redrawing districts immediately. The same rule broken only twice in 25 years, both times producing Republican electoral benefits. Tennessee, Memphis, carved into 3 pieces, its concentrated Black Democratic voting population dispersed across 3 Republican-leaning districts, the state's last remaining blue congressional seat surgically eliminated by the legislature that expelled Black representatives for peaceful protest. 3 states, the same election cycle, the same directional outcome, the same Supreme Court providing institutional cover at every step, waiving its own procedural rules, abandoning its own precedents, and responding to documented critique not with legal argument but with personal attacks on the justice who made it. This is not 3 separate states independently reaching similar conclusions about their congressional maps. This is a coordinated electoral strategy executed through the redistricting process and protected by a court whose selective application of its own rules follows a 25-year pattern of consistent partisan directionality. Justice Jackson named it precisely an unbridled assertion of power, not law. Not neutral judicial review, not principled constitutional interpretation, and raw institutional power deployed to produce specific electoral outcomes for a specific political party, documented, time-stamped, on the permanent public record, and happening in plain sight.